Looks like he's going to be disposing of both cases, correct?
Yes, that's correct.
All right, we have two cases called now, 24 CR 303 and 0304. Each of them similarly allege that on or about January 11th, 2024 in Jefferson County, Texas, you committed the third-degree felonies of, this is deadly conduct, discharging a firearm at or in the direction of others, namely a vehicle. All right, you are Mr. Bennett?
Correct.
Okay. And Mr. Dusler is here representing you. And do we need a formal reading of these indictments or summary as the court just gave? Is that sufficient? These are third-degree felonies, Mr. Bennett, which mean if convicted, you face no less than 2, no more than 10 years confinement in prison in each case. And you can also be fined up to $10,000. You understand the punishment range applicable in each of these cases?
Correct.
Agreements have been reached where you would be placed on deferred or unadjudicated probation on each case. Is that right, everybody?
Yes.
Which will be up, which can be up to 10 years in length, fine $500. These would run concurrently. Do you understand?
Correct.
If I follow this agreement in each case, you have no right of appeal. Do you understand?
Correct.
How do you plead in each of these cases? Guilty or not guilty? That you, how do you plead in each case? Guilty or not guilty? I'm sorry, guilty?
Correct.
Are you pleading guilty in each case voluntarily on your own free will and because you are guilty?
I guess so, yeah.
I'm sorry.
I guess so.
Yes, you are.
Correct.
Yes.
I show you what's marked in each case as States Exhibit 1. Did you sign those documents voluntarily?
Correct.
Did you understand them, discuss them with your attorney? Are the contents all true and correct? Yes?
Yeah, correct.
States Exhibit 1 is tendered into evidence in each of these cases.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read them. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so?
Correct.
States Exhibit 1 is made a part of the record for all purposes. Pre-sentence reports waived?
Yes, sir.
Stand by, please. All right, I'm looking at this probable cause affidavit.
That's right.
And what happened here?
Somebody showed him my car.
So you quite
At this point, everything looks routine. The defendant has already pleaded guilty. The plea agreement is on the table, and it seems like this hearing is about to wrap up in just a few minutes. But watch closely, because Judge Fleischer is about to read one document that changes the entire direction of this case. Sometimes it's not the guilty plea that matters most. It's the facts hiding behind identity.
At other people.
I was actually,
You didn't even know who you were shooting at, did you?
yes, I did.
Well, that's
I
not
see
what
some-
these people say.
I
These
seen him-
people,
I seen him run towards my car, and I discharged my firearm. That's it.
at
That's all.
what? Let's see. You,
I'll be honest with you.
Waji
Correct.
Hamad, let me speak. Waji Hamad, who owns Last Call Liquor, it was struck by several bullets. He wanted to file charges. Were you shooting at Last Call Liquor for some reason? Huh?
Correct.
Well, that's what got struck by your wild bullet fire.
Man, I got hit in the midst of,
Juan Rojas, whose passenger car was struck by several bullets coming from Bennett He wanted to file charges against you as well. Were you shooting Juan Rojas for some reason?
Incorrect.
You shot at it. It hit his passenger vehicle.
I wasn't trying to.
Huh?
My bullets went straight.
Oh, you don't think that can happen when you fire 51 bullets?
Correct. That's what happened.
What do you think? Is that too? Are you watching movies? I mean, 51 bullets. What were you firing it from? What kind of weapon was it, and what was the magazine?
Glock 45. And
How many times did you reload?
3 times.
Sir?
3 times.
You reloaded 3 times. Who in particular were you shooting at that you obviously missed? Who were you shooting at in particular? It's not supposed to happen.
Did you catch that? 51 rounds and 3 reloads. That's the moment this hearing shifts from paperwork to public safety. The judge isn't just hearing numbers, he's picturing dozens of bullets flying through a city where innocent people could have been killed. Regardless of why someone claims they fired, courts also focus on how reckless those actions were. What do you think? Does self-defense still apply after firing this many shots? Let us know below.
Innocent. They shouldn't be shooting at you, and you shouldn't be firing 51 rounds at different people who weren't involved.
I was doing what I had to do to protect my child. If you was in that situation, you would have done the same thing.
Oh my God!
I'm sorry, sir. You're incorrect. I would be responsible in what I'm shooting at.
Correct.
If you would have killed anybody, you'd have been charged with murder.
Correct.
In spite of what your intentions may have been.
Correct.
Okay. What were these?
This is a critical legal point. Judge Fleischer isn't debating whether the defendant felt threatened. He's explaining something every jury considers. Intent doesn't always erase responsibility. If innocent people die during reckless gunfire, prosecutors can still pursue extremely serious charges. The judge is reminding him just how close this situation may have come to becoming a homicide case.
What was someone shooting at you for? Why were they shooting at you? What provoked this? You have no clue? For no reason? Is that what you're telling me? For no reason, somebody just started shooting at you unprovoked? I know it can happen, but that's not what normally happens in this courtroom.
Can you go ask them?
I'm sorry?
You can go ask them.
Are you being a smart aleck to me?
No, I'm saying.
Who is it?
I don't
Who
know
is it? Who is it? Who is that person you want me to go ask? What's their name? So why would you say something like that to me? Go ask them. That's just being a smart aleck. Is that your nature? You're reckless. Is that your nature to be a smart aleck?
Just,
That's rude in this courtroom. That's rude. Have you ever been arrested before?
correct.
Is that yes?
Correct.
I'm asking you a question. I'm not making a statement. Or have you been arrested before?
Correct.
How many times?
One time.
For what?
Yes.
This? I'm not talking about this event.
No.
For shooting at another time?
No. Correct.
Do you want to go out there and sit in the cell for a little while? What were you arrested for, is my question. Why am I having to pull this out like I'm a dentist pulling your teeth out?
Do you have any other arrests besides
No.
this?
That's what I'm asking you. You've never been arrested before other than this,
My
right?
first offense. I'm not understanding why I'm getting 10 years probation.
Huh?
This is my first offense, so I'm not understanding why I got 10 years probation. That's all I'm saying.
You're not going to get 10 years deferred probation with me. We're setting this for trial. We'll let a jury decide your fate. That's what.
Here's where things start falling apart. Instead of reassuring the judge that he accepts responsibility, the defendant starts questioning the probation offer itself. In court, attitude matters. Judges often look for accountability, consistency, and honesty before approving negotiated plea deals. Right now, the judge is beginning to wonder whether this defendant truly understands the opportunity sitting in front of him.
Happens. When you're indecisive, these are all situations when you plead guilty, you have to convince me that that's what you want to do. Mr. Dusler, we're setting this for trial. Do you want him to represent you at trial? Are you the public defender on this?
Yes.
You don't even have a job?
Great. Wound up breaking my leg. I broke my finger in my 2 years.
When?
Like 3 months ago.
Okay, before that, what did you do for work?
Landscape.
How much did you make for landscaping? How long were you a landscaper?
7 months.
Before that, what did you do?
I was working at Sun.
At Sonic?
Checkers and stuff like that. Just really fast food. I wasn't really working too much. I was trying to get into the plant, but you know, that's a hit or miss.
Well, you won't get in with this over your head. We're going to set this for trial, and we'll let a jury decide. By the way, juries cannot give deferred or unadjudicated probation. If it's probation, you're convicted for the rest of your life for a felony if they give you probation. And you're looking at up to 10 years on each case, but it would be for a jury. Jury can't give you deferred or unadjudicated probation. You can only get this from the court. And I'm not accepting his pleas in the manner he has presented to me.
So
We're going to go to trial. Mr. Dusler can continue to represent you. He's a fine lawyer. Is that what you want to do? Or we can replace him and get somebody on the trial docket wheel.
And there it is, the biggest turning point of the hearing. The plea deal that could have kept this conviction off the defendant's permanent felony record is now off the table. By refusing to accept the guilty plea as presented, Judge Fleischer sends the entire case toward a jury trial instead. It's a powerful reminder that plea agreements aren't automatic. They still require the judge's approval.
You want it to get resolved, we're going to get replaced me. So telling us.
I'm about to go. We'll figure it out.
Mr. Bennett, you and I have gone over this at length, and while you feel that 10 years is a long time to be on probation, you understand that the court was going to cut you a break by giving you deferred adjudication.
Also, I can shorten it by a third, but for people who do,
Exactly.
which I do every day.
Since you've never been on
But
probation.
that's not going to be applicable in this case.
Since you've never been on probation before, the district attorney and the court were going to cut you a break and offer you deferred adjudication. You may not like the length of the term of probation, but that's generally what the judge.
It's in the place to sell it. I mean, it should have been done a long time ago before we come up here.
It was.
And that's, so do you want to keep him for trial or not? Yes or no?
You want to replace me and let him get a different lawyer, you can get it to court quickly.
It's your option. He's a good lawyer. There is no answer. You will, under the rules, you will be representing and we'll set these for trial. Get a resetting from that lady and we're going to try this one.
Judge, I think he's responding now.
I really just got to think about it. That's a lot. Really
Get
a
the
lot.
resetting. Mr. Dusler is your trial lawyer. He's a fine trial lawyer. Get a resetting. We're going to trial. Heather Boudreau is next.
What started as a hearing, expected to end in probation, has completely unraveled. A few uncertain answers, arguments with the judge, and hesitation over the plea agreement changed everything. Now a jury, not the judge, may decide this defendant's future. One courtroom conversation can completely alter the course of a criminal case. Do you think the judge made the right decision, or should he have accepted the original deal? Share your thoughts in the comments.